So now in this class, we are going to learn about insurance contract. What is insurance contract? Now, insurance contract is a contract whereby the insurer, that is the insurance company, promises to pay benefits to the insured or on their behalf to the third party if certain defined events occur. So if you have studied contract law, I'm not sure whether you've already studied contract law. What is a contract? Did you study contract law before this? Yes or no? So
No.
just in case you have studied, so let me just brush your memory a little bit. What is a contract? What is the definition of a contract? The definition of a contract is an agreement that is enforceable by law is a contract. Now, what gives the enforceability factor? So there has to be a promise which is accepted, supported by a consideration, right? So that enables the agreement to be enforceable, and that makes it a contract. That's interesting, right? So contract law is also a very interesting subject, and contract forms a part of our lives, just everyday lives. In fact, for example, it's not part of insurance law, but just to set the perspective for you, if you just go to the ice cream store and purchase an ice cream, that's a kind of a contract and an exchange that's taking place there, right? So you're not even aware, but there's already a contract that is taken, kind of a enforceability factor is there's an exchange that has taken place. You're not even aware. You board the bus, for example, a public service bus, and then there is exchange, or you board a taxi, for example, a public taxi. Again, there is a kind of a contract that is taking place. It may not be in writing, but of course, the person who is the passenger, enters into a kind of a discrete contract there. You don't even know. Yes, I'm not moving the screen just to set the perspective. I'm just giving you an example first, giving you an introduction, and then we will go through the slides as usual. Okay, so I'm just talking about a contract before we delve into the aspect of insurance contract. In fact, I've already told you what's insurance contract, but just giving you an example or to just set the perspective into what is a contract. I'm not sure whether you've already studied the subject earlier. Well, so contract in law, it would mean where there is an agreement that is enforceable is a contract. Now, talking about insurance contract, what is an insurance contract? So insurance contract is a contract whereby the insurance company promises to pay benefits to the insured or on their behalf to a third party if certain defined events occur. So basically, in an insurance contract, there are 4 elements, just like in a normal contract. The 4 elements, as I said earlier: offer and acceptance, a promise to pay, the promiser, promisee, offer and acceptance, consideration, legal purpose, and there are competent parties to the contract. Why we are talking about competent parties? A party is considered competent where he is capable of entering into a contract. For example, say an insane person is not capable of giving his consent or entering into a contract. So we say that party is not a competent party. So therefore, just like a normal contract, an insurance contract is a contract where there is an offer, acceptance, supported by consideration, it's for a legal purpose, and then there are competent parties. It is done by competent parties. Okay, so now having set the perspective, let's move on through our slides and see what the slides say about insurance contract. So insurance contract is a contract between the insurer, that is the insurance company, and the insured, that is a person who is purchasing the policy, or has purchased the policy rather. So the insurer undertakes to compensate the loss that has occurred, the loss or the damage that has occurred to the party who has sought the insurance and is covered under the insurance Next is a party who obtains and or is covered under the insurance policy contract is called as the insured, and the insured is expected to pay a fixed amount of money on the happening of a certain event. Now, just referring to the law in Spain, we are going to study it in the international perspective. So we are going to, just in brief, go through certain laws which are prevalent in different countries in different parts of the globe. Now, the law in Spain, Article 1 of the Insurance Contract Act of 1980. It defines a contract of insurance as a contract by virtue of which the insurer agrees for a specific consideration, that is premium, and when an event occurs, the risk of which is the object of coverage, to indemnify within the agreed limits the damage suffered by the insured, or to pay a capital sum, a rent, or other agreed compensation. Next is reference to the law in the UK. So there is no statutory definition of an insurance contract in UK. However, in the case of Prudential versus Commissioners of Inland Revenue, Justice Channel, while referring to an insurance contract, he observed that, namely a contract whereby one party, the insurer, promises in return for a money consideration, that is a premium, to pay the other party, the insured, a sum of money, or to provide them with corresponding benefit upon the occurrence of one or more event. Next is reference to Finland. Under the Finnish civil law, insurance contract is said to be based on an agreement or a contract between the insurance company and the policyholder. After the conclusion of the insurance contract, the insurance company is to transfer the insurance policy to the policyholder. The insurance policy or document should contain the most relevant points of the insurance contract and the terms of the policy and all of the requirements stipulated in the Finnish Insurance Contract Act. Next is a brief reference to the law in Greece. Article 1 of the law 2496/97 states, by the insurance contract and insurance undertaking, the insurer undertakes to make payments or, if specifically agreed, to make provision in kind to the other party, that is a policyholder, or to a third party in return for a premium or the occurrence of an event on which it has been agreed that the insurer's obligation depends, that is the insured event. Now, talking about Germany, they have this Insurance Contract Act, VVG, and under Article 1, it deals with the main obligation of both the parties. So by making a contract of insurance, the insurer undertakes to cover a certain risk of the policyholder or a third party by paying a benefit up to the date on the occurrence of the agreed insured event. The policyholder is obligated to pay the agreed contribution, that is insurance premium, to the insurer. Now, a reference to the law in India. So in India, the definition attributed to an insurance contract is that of the definition of a general contract under the Indian Contract Act. What is the definition there? An agreement that is enforceable by law is a contract. So what is the definition of an agreement? An offer plus acceptance, right? Offer and acceptance is an agreement supported by consideration and thereby giving it enforceability is a contract. So an insurance agreement between the insurer and the insured that is enforceable by law is an insurance contract. So the primary law that governs insurance in India is the Insurance Act 1938, that is the Insurance Act, and the Insurance Regulatory and Development Authority Act 1999, the IRDA Act. A reference to the law of the United States. Dating back to 1944, insurance in the US was not considered a commerce. Thereby, it was governed by general federal laws or union laws or, central laws. Subsequently, there was a judicial precedent or a case that happened, and there was a judgment, that is judicial precedent, that stretched the scope of insurance law. So in the United States versus Southeastern Underwriters Association, the Supreme Court held that Congress could regulate insurance transactions that were truly interstate. So the ruling in this case made the insurance industry subject to federal regulation, that is a central regulation, and provided the legislators the authority over regional, interstate, and international commerce, including insurance policies sold out to each state. Consequently, the Congress enacted the McCargan-Ferguson Act, that is 15 USC 1011, which permitted the states to have their own insurance laws. However, the Sherman Act, the Clayton Act, and the Federal Trade Commission Act were made applicable to the insurance business to the extent that it was not covered or unregulated by the state law. So under this particular McCarran-Ferguson Act, states are granted the power to regulate the insurance industry, and the state insurance laws override most federal statutes, while some federal laws, such as tax laws, are always commanding. So thereby, the factor that needs to be examined primarily in an insurance dispute in the US is that whether the insurance covers a business or just the peripherals. Peripherals in the sense the other factors, whether it's just the mainstream or the peripherals. So if the insurance covers business, then state laws apply. And if the insurance covers the peripherals, such as tax and so on, then the federal laws apply. The Competitive Health Insurance Reform Act of 2020 restricted anti-competitive behavior, and insurers who be engaged in anti-competitive behavior would be made liable under the federal laws. Next is a reference to the United Arab Emirates. Here, insurance contracts are governed by the UAE Federal Law number 5 of 1985, the Civil Code, and the primary legislation on the establishment and regulation of insurance organization and activities in number 6 of 2007. Apart from that, there is different free zone jurisdictions, and they have their own insurance law. For example, you have the DIFC in Dubai, and they have a set of insurance regulations there. So we're talking about the federal regulation here. Procuring a contract of insurance without an insurable interest is haram or prohibited under Sharia law. However, the concept of insurable interest is not clearly defined in this law, except a mention in the commercial maritime law, which expressly prohibits anyone from benefiting from an insurance policy unless they have a lawful interest in the subject matter of the policy. So this reference may be extended to even other insurance policies. So next is reference to the Sultanate of Oman. One minute. So in Oman, insurance contracts operate as a contract of adhesion. Remember, we studied that insurance contracts are contracts of adhesion, where the insured is bound by the terms and conditions set forth in the insurance policy. Why did we say their contract of adhesion? When we learned it during the first class, we said they are contracts of adhesion because there is little or no scope of negotiation. So insurance contracts, therefore, cannot be easily terminated by the insurer unless there is an order from the court of law to that effect. This was held in one of the cases where the court held that it was not possible for the insurer to negate his obligation to cover the insurance risk under a specific judgment to that effect was issued by the court. Thereby, an insurance contract is a special contract that has the elements of a normal commercial contract, where the insured seeks to alleviate his loss and get compensated. So a life insurance policy may be seen as an investment. It was also considered as a contract, however, of adhesion, since it has no scope of bargaining or negotiation, but the insured is bound by the statutory policies, terms, and conditions that are mentioned in the policy contract. An insurance contract establishes a relationship and agreement between the insured and the insurer, where the parties agree to abide by the terms, conditions, and warranties expressed in the insurance contract. The insurance contract acts as a protective risk device against losses or damages that may be apprehended in the regular course of transaction, business, or utility. So what are the elements of an insurance contract? The normal general elements. And of course, they have specific elements. What are the normal general elements? Offer plus acceptance. is an agreement. Then there is a valid consideration, capacity to contract, lawful object, and lawful purpose. So thereby, there must be a valid offer that is acceptable or accepted to form an agreement, and which agreement should be enforceable in nature. For an agreement to be considered enforceable, it must be made by parties competent to contract. There has to be the element of consensus ad idem. That means all the parties in the contract must agree with each other. There has to be meeting of minds. There must be a valid consideration, that is something for a price, a consideration, and the purpose of the contract must be lawful. Consideration in an insurance contract is in the form of premium that is paid by the insured to secure the policy. Now, apart from that, the other special clauses that need to be there in an insurance contract are indemnity clause. Now, this is an essential clause in an insurance contract. All insurance contracts except life insurance policy have an indemnity clause because personal insurance risks are not calculable. Thereby, it cannot be estimated. Thereby, life insurance contracts are not indemnity contracts. Under this clause, the insurance company or the insurer covenants to make good the loss, compensate the loss or damage that is caused to the insured within the ambit of the scope of the policy. So here the insured or the policyholder must prove that there is an apprehension of loss. There is a fear of loss. He kind of foresees a loss in case of occurrence of in case of occurrence of the contingent event to be covered under the scope of the policy. Now here, the compensation that will be approved for disbursal by the insurer, the insurance company will be to the extent of the total amount of insurance policy obtained be responsible for the disbursal of that amount. So indemnification, of course, cannot be more than the amount that is insured. So if the insured gets more amount than the actual loss, the insurer or the insurance company is bestowed with the right to reclaim the amount. If the insured additionally receives a compensation amount from a third party, then what happens? After being indemnified by the insurer, then the insurer will have the right to claim the additional amount that is received by the insured from the third party. Next, we have the premium clause. Now, which specifies the amount of premium that needs to be paid by the insured or the party who obtains the insurance policy. Premium once paid will not be refunded. However, there are certain exceptions wherein such an exception is mentioned in the policy. Next is the question of insurable interest. Now, this is something that we learned during the last class. Insurable interest, that is a relationship or the nexus of the insured to the subject matter with the policyholder. So there must be an insurable interest which is examined so as to process the policy and or the claim. The principle of proximate cause. What is the principle of proximate cause? The cause of the loss must be proximate and not distant so as to determine whether the cause of loss is a peril that has been insured. Next is the concept of uberame fide, that is utmost good faith. Now, an insurance contract is founded on the principle of absolute good faith, wherein the parties to the contract are obligated to disclose all the material facts pertaining to the contract, subject matter of insurance, and no material fact must be withheld. So the Latin term here for utmost good faith is uberame fide. Uberame fide means utmost good faith. That is a principle of absolute good faith. Next, we have the limitation clause that will specify the limit or the extent to which the insurance company will cover the loss. Next is the exclusion clause that will state the conditions or occurrences where the insurance company will not cover or compensate the loss. Next is the warranty clause that is express certain conditions and promises in the insurance contract which may be implied or even expressly stated. Next is the co-pay clause. So this clause finds its place in health insurance contract where the insured is expected to co-pay while obtaining any medical service. as per the terms that are mentioned in the health insurance policy contract. So the percentage of co-payment may vary depending upon the type of insurance policy. Next is the assignment clause, which does not permit assignment of the policy. What is assignment here? Not the normal assignment that you do. Assignment is to assign. That means you transfer the policy to someone else. So here the assignment is not possible. It does not permit assignment of the policy unless the insurance policy expressly permits it. If the insurance policy, the terms and conditions says yes, assignment is possible, then yes, they can transfer it to someone else. Like, for example, life insurance policies are considered as assignable. Why? Because in certain life insurance policies, normally in life insurance policies, they have beneficiaries there, right? However, fire insurance policies, here, if the contract permits assignment, if the clause is mentioned in the terms and conditions of the policy, then the effect of assignment will lead to a new contract. Otherwise, if there is no assignment clause, the insurance policy cannot be transferred or they cannot be assigned, say, to their heirs or the benefactors, beneficiaries, and so on. Next is subrogation clause. I spoke about subrogation earlier during the first half of the class. That is, it permits this insurance company to obtain recompensation from a third party was caused the loss to the insured after compensating the loss of the insured. Next is a cooperation clause. That is a clause that seeks assurance from the insured part that the party would render all required assistance that may be required in case of an investigation process in a claim. So here, the insured is expected to divulge all relevant information, necessary reports, and documents that may be available to prove a legitimate claim and not procrastinate, or that is not delay. So how would you file insurance claims? The first step of filing an insurance, this is very important and something practical. Listen carefully. How would you file insurance claims? The first step is, or the primary step is, to report the incident, whatever has occurred, to the nearest authoritative body or the police department in case of an accident-related policy, personal claim, fire accident, and so on. Police reports and all relevant investigation reports must be obtained by the policy holder, that is the insured. The next step or simultaneous step is filing an application of claim with the insurance company or the insurer. That is, fault or no fault is assessed at this stage. That is when, after you file the application, they're going to assess fault or no fault. Now, what will the insurance company do after receiving your application? Upon receipt of the application, the claims adjuster, there'll be a person who plays the role of the claims adjuster. He will be delegated on behalf of the insurance company to investigate the claim further. This claim adjuster may interview the claimant or the policyholder or any other witnesses and prepare relevant reports based on his or her study. The claims adjuster will gather material evidence in the form of medical evidence, if the case requires so, and carry out site inspections and so on, gather information from the police, and then submit it to the insurance company, underwriters, and so on. In some cases, the claims adjuster plays the role of the underwriter, and then finally a conclusion is drawn as to legitimacy of the claim and accordingly calculate the compensation. Now, at the third stage, either the claim is approved or rejected, or more information is sought. Thereby, here, as the third step, based on all evidence that is collected, the insurance company may directly approve and calculatively disburse the amount. If more information is sought, then the insured must comply with the request and provide all relevant information that is being sought, and both the parties are expected to not procrastinate and act legitimately within the purview of the law and policy contract. Conflict resolution, if any, that is in case of rejection or less amount approved, then what happens? In this case, the insured, in case he senses the probability of injuries or damage assessment, and the impact is being unfairly represented and handled, then the insured party may take recourse to legal help, that means might file a case. Further, in case of disbursal report that is handed over to the insured, and the insured party, if is dissatisfied with the claim amount, The party can file an application highlighting the discrepancy or the difference of the amount and the dissatisfaction with evidence, that is, with all proofs. Now, court intervention. If the conflict is not resolved, the matter may or may not be resolved internally, but may grow into a dispute, and court's intervention may be needed. Now, if the conflict is solved, then at this stage, a settlement agreement is drawn. Means the parties, they say, okay, fine, we will settle the matter and we'll draw a settlement agreement. And the amount negotiated is then released or disbursed to the insured. In case of a suit filed before the court, the proceedings would be initiated and the parties will have to await the final judgment decree, and then the aggrieved party, there is a party which is aggrieved, or the injured party, may file an appeal or move an application for execution of the decree. So it may happen that during the litigation, parties may seek a compromise and may decide to close the matter by filing a settlement agreement that has been negotiated between the parties. So with the intervention of the court, the settlement amount will be released to the petitioner or the insured. And the claims procedure, of course, it varies depending upon the type of insurance with regards the loss or damage, or propose the loss or damage that is caused and or the maturity of the policy. So what are the defenses that are available to the insurer? Some of the defenses that are available for the insurer for denying or rejecting a claim are as follows. One is invalid documents produced and misrepresentation. Who is the insurer? The insurance company. What causes could the insurance company give in defense in case there is a case? The defenses for them would be, okay, there is an element of fraud. Improper documents were produced. There was misrepresentation. Not all vital information, not all significant or important information was disclosed to them, which was mandatory to be disclosed to decide on granting the insurance policy. So concealment of relevant facts is a defense. So the insurance company will easily go scot-free. Next is incontestability. Incontestability by virtue of incontestable clause is present in the insurance contract. That means you cannot file a claim before the court, so it need not be contested. Lack of coverage and proximate cause is not established. So there are people still joining in. Well, we're coming to the end of the class. So proximate cause is not established. So these are the 6 defenses that the insurer can rely on so as to defend his case, or rather the insurance company's case. Insurer is the insurance company here. So any questions?